Hi, I'm Laura and welcome to Views on the News, a programme which invites volunteers to present their points and raise questions on vital issues of the day. Today we're looking at international justice and have asked writer and coordinator of the London Legal Salon, Luke Samuel, to respond.
Hi Laura, and thank you to WORLDwrite for inviting me to respond on this issue.
Hi Luke, I'm Camilla. I'd be interested to hear your thoughts on the current Ratko Mladic trial. Do you think a mother who has lost sons in the atrocities in Bosnia will care of the nationality of the court who convict Mladic? Surely she would just want to see him imprisoned as soon as possible. And surely it's these people, the relatives of Mladic's victims, who are most important to consider in this debate. My concern is that debating the nuances of the ICC may result in such an ideological gridlock that these criminals end up going free. Who benefits by that?
Well, Camilla, I think there are a couple of dangers inherent in your question. The first is there seems to be an assumption that it's us in the West who should decide what is best for the people of the former Yugoslavia. I think the only people who know what is best for the people of the former Yugoslavia are they themselves. Picking up on another issue which is present in your question, you suggest that the people who died at Srebrenica were the victims of Ratko Mladic. Now, I would suggest that these people aren't the victims of Ratko Mladic as such, they're the victims of a civil war. The reason why it's important to recognise that they were victims of a civil war is that there were many complex political and social factors at play in the course of that war. The real question arises as to what moral authority the West now have to prosecute Ratko Mladic, given that one of the key political factors that led to the Srebrenica massacre, the crime for which Ratko Mladic is now being tried, was the intervention of the West in the Civil War. Chiefly, you can identify that in 1993, the designation of Srebrenica as a safe zone by the United Nations had a severely destabilising effect on the conflict, chiefly because, effectively, Bosnian Muslim troops were able to use the UN safe zone as a means of targeting Serbian troops on the borders of Srebrenica. They flew their helicopters over the no-fly zone over Srebrenica, and this was all effectively in defiance of the UN-designated safe zone. What this really did was gave the Serbian forces the idea that they weren't up against just the Bosnian Muslims and the Bosnian Croatians, but that they were also up against the forces internationally who were then intervening in the conflict. So that international dimension actually had a really destabilising impact on the area, and undoubtedly was one of the factors which led to the massacre happening in the first place. So I think that it does matter who tries, if anyone, tries Ratko Mladic, and I certainly don't think that the West, having intervened in the conflict and played an important part of forming the material conditions which led to the massacre, have the moral authority to do so.
Ratko Mladic participated in this joint criminal enterprise in order to compel NATO to abstain from conducting airstrikes against Bosnian Serb.
Hi, I'm Andrew Mirage. The ICC was created in 2002 as a tribunal to prosecute individuals for crimes against humanity and war crimes. But there have been many examples of war crimes in Iraq and Afghanistan, which were never discussed in an international forum. So Luke, I'd like to ask, does the ICC really help stop war crimes? Secondly, Luke, there have been several temporary courts dating as far back as 1945 with the Nuremberg International Criminal Tribunal, which was also designed to prosecute war criminals. So I'd like to ask, in your opinion, is there a difference between the international courts of today and Nuremberg?
Well, Andrew, I think that international law targets very specific conflicts. It targets those conflicts which the West see as being fought in a way which is unacceptable or illegitimate. But yet at the same time, it completely allows for humanitarian intervention. So I think that international law targets a very specific kind of conflict. And that's why, for example, under the Rome Statute, the statute which governs the activity of the International Criminal Court, every single indictment that has been issued relates to a conflict on the African nation. And I don't think that's a coincidence. It's because, effectively, the law anticipates that there's going to be certain conflicts which are fought in a way which are unacceptable and other conflicts which are fought in a way which are acceptable. And I think that's a very problematic distinction. And moving on to your second question, which is what's the difference between contemporary ad hoc international tribunals and Nuremberg? It's obviously a very, very complex question, but I think the key distinction is one of context. And I think there's two important ways of understanding the differences in context between the international ad hoc tribunals of today and Nuremberg. The first is really what they were dealing with. If you look in 1949 and what the Nuremberg trials were attempting to dealing with, the German Nazi leadership were not on trial for their involvement in a civil war. They were on trial for seeking to implement a pan-European and eventually international program which would have led to the extermination of Jewish people across the world. Now, that's very, very different to what contemporary ad hoc tribunals are attempting to dealing with, which are always domestic conflicts or civil wars. Now, actually, I would make the argument that the Nuremberg trials, in the course of those trials, the West and the governments that were running the trials were the only people with the moral authority to try the Nazi leadership. And there was broad political consensus at the time that if the Nazi leadership were to be tried, then the collection of governments who were running the Nuremberg trials were the proper people to do it. That is completely different to the international ad hoc tribunals you see today.
The court has established mechanisms of the highest legal standards to ensure that proceedings are fair, impartial and public.
Hello Luke, I'm Laura. I think the very idea of international courts reveals the imbalance of power between different states. Less economically developed states that have not had the capacity to develop full legal frameworks are forced to rely on the resources and expertise of more economically developed states to pursue their legal goals. Dependent states are then rendered even less capable of establishing the internal institutions they need. My question then is the international court's idea of universal justice an impossible one until we have universally equal relations between states?
Laura, it's a great question, and I agree with the tenor of what you're saying. It's worth noting that the ICC does not only intervene in states for reasons of lack of institutional development. If you look at Kenya, for example, Kenya is a country with a functioning judiciary and a functioning prosecutorial system. And they've recently made an application to the ICC to try individuals who are currently indicted and awaiting trial at the ICC, individuals who were allegedly involved in post-election violence in Kenya. They've made an application to the ICC to have them tried domestically. Now, the ruling by the ICC in response to that application was really interesting because they didn't take issue with the institutions of Kenya. They were able to recognise that, in fact, the institutions themselves were capable of running a trial of these individuals. What they picked up on was that the Kenyan government's investigation into the violence itself was insufficient. So what the ICC did in the course of that ruling was effectively tell the Kenyan government that they weren't investigating crimes committed on their own soil, effectively against their own people, in a manner which was satisfactory to the ICC. And those individuals will face trial at the ICC in the coming months. So you can see that their intervention is not just limited on the basis of what view they take of institutions. They actually take quite an explicit role in intervening in those conflicts where they see the governments as inadequate in some way in dealing with the questions that the ICC will then go on to try. Now, I think that you hit the nail on the head when you said that universal justice is not possible in a fundamentally unequal world. But I'd go further and say that the very concept, the very idea of universal justice is a very difficult one, because I think a really important component of justice is that it arrives at results which are conducive to democratically agreed rules of behaviour and moral norms. And I think democracy is absolutely key in our conception and understanding of what justice is. And I simply don't think that a truly democratic model of justice could ever be internationalised in a way which would make it universal. I think that certainly on the basis of the world that it is now, We live in a world full of countries with differing material interests and peoples made up of differing material interests. And to imagine that somehow an international conception of justice could be arrived at whilst retaining that key democratic idea that justice should be somehow democratic, I simply don't think is possible.
Hello, my name is Maria, and as a citizen of the world, I am obviously concerned about world equality and world justice. Therefore, the work of the ICC worries me, as I feel its sense of justice is biased and one-sided. Recently, an American soldier killed 16 civilians for no apparent reason in Afghanistan. After he was sent home, and it is believed he had a mental breakdown, nothing was done about it. In another instance, back in NATO's war against Kosovo, the Clinton-Blair coalition sent missiles to destroy Radio Television Serbia in Belgrade, which killed 16 civilians and injured another 16. NATO then claimed they wanted to destroy RTS and not the TV transmitter, and again, nothing was done about it. It seems that when the West does some attack, it's defensible, and when anybody else does something, it is a crime. The line between what's a crime and what's not is very blurred according to who does it. So my question, Luke, is how does the ICC decide what is a war crime? When is an action in war legitimate and when is it a crime? And who decides that?
Maria, the decision for the ICC to prosecute is taken by its lead prosecutor, who is a lawyer based at the court and who changes periodically. The decision to prosecute follows an investigation by that prosecutor into a given state of affairs. Now, an investigation can be launched in one of three ways. Either the UN Security Council can oblige the lead prosecutor to undertake an investigation, either a state party can ask for the lead prosecutor to undertake an investigation, or the pre-trial chamber at the International Criminal Court can ask the lead prosecutor to undertake an investigation, which will usually be done as a result of them receiving a number of complaints from a given area. Now, the decision to launch an investigation is a fundamentally political one. It's important to recognise that the way that the law is drafted means that it's able to catch certain acts of war whilst ignoring other acts of war, specifically the ones that you mentioned in the course of your question. Now, those that you mentioned in the course of your question will never be described or legally caught as crimes against humanity, because a crime against humanity is a particularly odious act which is undertaken as part of a state policy. Now, Western governments will always be able to argue that interventions which are justified on a humanitarian basis do not meet the threshold of a crime against humanity because, for example, it's not part of that intervention. There's no policy there to kill civilians, for example, even though that is an inevitable consequence of these interventions. So the way that the law is drafted is meant to catch very specific offences whilst ignoring the kind of acts of war which you talk about. Now, the really damaging impact of the way that the law is drafted is that it draws what I think to be an artificial distinction between legitimate legal acts of war, such as the ones you describe, and crimes against humanity, or acts of war which Western governments see to be illegitimate. In reality, I don't think we should be looking at these conflicts in legal terms. We need to look at all acts of war in a political context. And I think that distinction between legal, legitimate acts of war on the one hand and illegitimate, illegal acts of war on the other is one of the more damaging effects of the way this law has been drafted.
And it seems unlikely that the prosecutor can ever really challenge the most powerful countries.
Hi Luke, my name is Dario. Leaving aside the official human rights motivations, why do you think international criminal courts have been instituted and are increasingly looked to? Is it an attempt by Western powers to justify their intervention around the world? Secondly, do you see any possible constructive evolution to or alternative to international criminal courts in order to implement concepts of justice and human rights in a neutral, democratic, international way?
Luis Moreno Ocampo, a jurist from Argentina, has a mandate to investigate war crimes around the world, but he and the court have faced criticism for ineffectiveness.
Dario, in response to your first question, I think the wider recourse to international courts is part of a delusion on behalf of Western governments that it's their job to play the role of a moral leader throughout the world. And the best way of doing that is to interfere and attempt to arbitrate conflicts in nations where they have no real power to resist your interference. I think this delusion that the West should play a role as a moral leader really comes as part of a collapse of any political purpose amongst Western governments. After the fall of the Soviet Union, governments in the West were faced with no real ideological opponents, no one to really fight a political battle of ideas with. What was left over was effectively, in order to give themselves some purpose, some way of justifying their political actions throughout the world, they instead attempted to intervene on a moral level, attempted to identify those countries and those wars that they thought were acting immorally, and attempted to play the role as moral interveners. And I think that shows a real shift from interventions on a political level to interventions on a moral level, which are actually far more dangerous. In relation to your second question as to whether or not there is any alternative or evolution of these courts, I think it's a mistake to see the courts as the real problem. The real problem is what the courts symbolise, and that is international law. The courts are merely institutions of the statutes that have been drawn up to bring these courts into existence. And the way that law is drafted at the moment, it places enormous power in the hands of Western governments to intervene in a state's affairs. And the way that international law is drafted, the very premise of international criminal law, is that Western governments and Western-run institutions are better capable of arbitrating these conflicts than the states are themselves. So I don't think that there can be any positive evolution of international courts because they're predicated and founded upon the principles of international law, which necessarily place power in the hands of Western governments.
Hello, my name is Barbara. I understand, Luke, that the ICC can only try a case if one or more states complains, and turning a blind eye may result in ongoing atrocities. Are there alternatives to the international courts that you would recommend? Also, Luke, remembering Hiroshima and Nicaragua, I note that the USA has not signed up to be governed by the International Court. Does that mean they consider themselves to be exempt?
Barbara, I don't think there can be any legitimate alternatives to international criminal courts because I think that the very assumption of international law that a set of governments are best placed to decide what's best for other countries is in direct conflict with the idea of sovereignty. The way that the law works, it lifts enormous power out of the people on the ground and places it in the hands of unaccountable Western lawyers and Western judges, which I think is directly opposite to the idea of sovereignty. Dealing with your second question, the United States aren't technically, legally outside the remit of the International Criminal Court. We know that non-signatory state parties can become subject of investigations. We saw that with Libya. Libya was not a signatory to the Rome Statute, but was nonetheless had an investigation and a prosecution launched against it. But politically, the way in which the law works, the way in which these decisions are made, politically it would be impossible for the US to be investigated or indicted because of the manner in which these investigations are brought around.
Hello, my name is Alex. I have an issue with the neutrality of the international courts when attempted to bring justice to the countries they seek to aid. It seems to me that organisations such as the ICC attempt to take on a sense of purity that they know and represent the one and true way to solve political issues. I was wondering, Luke, what you thought about this. Because when political conflicts arise, they are often riddled by complexity and opposing points of views. Can the ICC be objective in serving justice to the country it aims to aid while representing other countries' interests?
Alex, I absolutely agree that the way in which these trials unfold is often in complete admonition of the complex concerns which are at play in the countries over which they adjudicate. A really good example of this was the recent conviction of Charles Taylor, who was the ex-president of Liberia. Now, that trial was initially held in Sierra Leone, which is the country in which Charles Taylor was alleged to have assisted in the attempted overthrow of the democratically elected government in 1992. The trial was initially held in the capital of Sierra Leone, but was then transferred to The Hague in 2006. And the reason that the lead prosecutor at the time gave for shifting the trial was that she thought that his continued presence in Sierra Leone would be a destabilising influence on the area. Now, that's a telling remark because it showed that in Sierra Leone, and obviously across the border in Liberia, where he was an elected representative, there was still support for Charles Taylor, and there was still support for what he had done in the course of the Sierra Leone uprising. The shift of that trial from Sierra Leone to The Hague was telling because it really showed how the ICC seek to ignore the complexity at play and also to ignore the fact that the people who they indict and then later try often retain political support in the countries that they're from.
Hi Luke, my name is Rebecca. I agree that legal intervention by the West in these international courts can seem patronising. But do you not agree that the intentions are good and that some reconciliation can come as a result of these trials? Critics say that ICC is not representative of the people, but neither are these leaders who committed these atrocities. Who can bring them to justice and provide reconciliation if there is not an adequate legal structure in place? Without such structures, tensions may continue to simmer, and grievances are often taken out on civilians rather than those truly responsible.
Rebecca, it's very difficult to suggest that these trials have brought around any sense of reconciliation. Only 2 of them have actually concluded. Look at the case of Thomas Lubega. There's absolutely no suggestion anywhere that his conviction for the use of child soldiers has had any impact whatsoever on the ground in the Democratic Republic of Congo. The resolution of problems there will necessarily have to come from the ground. The same in relation to Charles Taylor. What was particularly interesting is on his conviction, there are a host of different reactions across Sierra Leone and Liberia. The reaction in Liberia is obviously one of anger. The fact that he was a democratically elected representative who had been tried by a foreign court for crimes alleged in another country. And even the reaction in Sierra Leone itself was mooted. There certainly wasn't overarching celebration of the fact that he had been convicted. And it's very difficult to identify any even indictment being issued or any investigation being launched which had any reconciliatory impact on the countries over which they adjudicate. Now, the evidence does point to the fact that these investigations have an enormously destabilising impact on the countries over which they adjudicate. If we look again at Libya, it's a great example of how an indictment issued by the ICC actually prolonged a conflict.
Just into CNN, the noose is tightening on Libyan leader Muammar Gaddafi. The International Criminal Court has just issued arrest warrants for crimes against humanity after Gaddafi's regime began a war against opposition civilians. We were expecting this to happen.
Yeah, well, it'll be difficult to get him, right? Because he ain't going anywhere, at least right now.
No one's been able to get him, the rebels, NATO, or anybody else. But
there are attacks, by the way, apparently NATO attacks underway in Libya right now, some of them fairly close to Tripoli.
The way it did this was quite straightforward. Gaddafi, in the course of the uprising, was politically weakened. When the indictment was issued, the states surrounding Libya, as they were all members of the United Nations, were obliged to cooperate with that investigation, which meant that had Gaddafi taken the option of fleeing Libya and going into exile and handing political power over, he would effectively had to have been handed over by any state to whom he crossed the border. This undoubtedly had effectively cut off Gaddafi's lines of retreat, leaving him no option other than to stay in Libya and cling to power for as long as possible. And that's just one example across the history of the International Criminal Court as to where indictments issued by the court have had an enormously destabilising impact. And there's certainly no evidence to suggest that the 2 trials which have actually concluded at the ICC, have had any positive impact in the countries over which they adjudicate whatsoever.
Hi, my name is Stephanie. I would like to point out that from Serbia in 1999 to Libya in 2011, humanitarian intervention has been a euphemism for wars of aggression. No matter how much they may boast about the effect of Western firepower and how collateral damage can be minimized, humanitarian intervention only seems to increase the suffering of civilians. And I would like to ask Luke, do you consider these international courts another form of humanitarian intervention? Secondly, can the idea of humanitarianism, assisting our fellow man, be rescued as the universal principle? Or is it a useless idea which in an unequal world will always be used to undermine sovereignty?
Stephanie, it's a very interesting question. One I would like to ask in response is, well, what's worth saving about the concept of humanitarianism? I think the more important concept we should seek to rescue or to recognise is solidarity. And the two are very different. Humanitarianism suggests that those people on the ground in the countries we're talking about are incapable of dealing with matters themselves. And that, for me, is an argument which is in direct conflict with sovereignty. Now, solidarity means that we recognise these struggles and we express support for them. But at the same time, we recognise that the people over whom we're expressing solidarity with are capable of resolving these situations for themselves. And I undoubtedly think that the assumptions behind humanitarianism and around humanitarian intervention are the same ones that drive the development of international law. Effectively, what is driving the theory of humanitarian intervention is the idea that Western governments are better equipped to deal with difficult moral and political situations than the people on the ground. And that's why I think international law will always be in opposition to an idea of sovereignty and an idea of self-determination. So I think that not only is international law part of the broader humanitarian intervention project, I also think it's in opposition to a more important value, which is solidarity, which expresses not just a sense of common interest between us and people struggling throughout the world, but also recognises that sovereignty is important to maintain and that people throughout the world are capable of dealing with these issues themselves.